Good afternoon. Today I have the pleasure of being joined by Brooks Holland of Gonzaga University School of Law. He's a professor of law there and the director of the Global Legal Education. Professor Holland is joining us today to talk about an upcoming Supreme Court case, Torres versus Madrid. Professor Holland was kind enough to write the ABA Supreme Court preview article for us on this case and really delve into some really interesting issues on police authority, the Fourth Amendment, search and seizure, and I'm excited to dig into those topics with you today, Professor Hollins. So if you could
Thank you
start
so
off
much
by
for hosting me.
setting up the case for us and telling us a little bit about the story of Roxanne Torres and how it got to the Supreme Court.
Sure. Roxanne Torres is in the Supreme Court because a few years ago, the police were investigating somebody else for criminal activity and came to an apartment complex to try to find this person. They were not successful in finding this person, but they saw Ms. Torres in a vehicle and approached that vehicle as part of their investigation. And when they approached her vehicle, they were in plain clothes and not marked clearly as police officers. Ms. Torres apparently became concerned that they might have been trying to rob or assault her, and so she hit the gas and took off in her vehicle. The police, because they were there for an investigation into criminal activity, became concerned, according to the evidence that's still in play in this case, and they fired shots at the vehicle as she tried to escape. The police claimed that they were concerned she was trying to run them over and might hurt somebody in the way she was driving. When they shot at the vehicle, they hit her with the bullets. She was able to continue driving for a little bit, but within a short period, the car stopped and she was not able to continue. She came out of the car and asked a pedestrian, a person in the area, for help, and then ultimately took off herself and fled, and spent about the next day trying to avoid apprehension and get medical treatment. And she ended up at a hospital in a neighboring city. And at that hospital, the medical personnel alerted the police that she was there with gunshot injuries. They came, and only then at the hospital did they formally arrest her for the crime they claimed she committed in fleeing from the police and attempting to injure them. She was prosecuted for that criminal case, and the criminal case was resolved, but she ultimately sued the police under the theory that they violated her Fourth Amendment right to be free from unreasonable seizures when they shot her as quickly as they did when she was attempting to flee from them in her vehicle.
So what is Ms. Torres claiming is the seizure here?
She's claiming that the police seized her when they shot her, that the police use of deadly force itself was a seizure. And that theory is not particularly novel at this point. The Supreme Court had held many years ago that when the police use force, and especially deadly force, they are engaging in what would qualify as a seizure under the Fourth Amendment. And that seizure, therefore, would have to be reasonable in the way the Fourth Amendment case law interprets reasonableness in different contexts. Sometimes we think about a warrant, sometimes we think only about probable cause. For the use of deadly force, the police would need to be able to show that they reasonably believe that Ms. Torres presented an imminent threat of deadly harm, death or serious physical harm, to the officers or to third persons.
And is that what the court's being asked to determine in this case, or what's the issue before the court?
No, we're testing a new boundary of whether the police use of deadly force constitutes a seizure, because here, Ms. Torres, in these unique facts, was able to get away from the police. When they shot her, they didn't stop her. She got away for a day, and they didn't catch her until she was at the hospital the next day when they formally arrested her. But a formal police arrest isn't necessarily the defining moment of a seizure for Fourth Amendment purposes. And Ms. Torres is arguing that when they put bullets in her body, they seized her, even if she ultimately was able to get away. But the police are arguing in defense to this lawsuit that because she escaped, she was never seized under the Fourth Amendment, and therefore a lawsuit that is premised on a violation of our constitutional rights under the Fourth Amendment cannot proceed. The lawsuit has not yet dealt with the issue of whether the police use of force, if it was a seizure, was reasonable under all the circumstances. This case is solely about whether the police seized her when they shot her, but she got away.
So if I'm hearing this correctly, if they had shot her and she hadn't been able to get away, the case wouldn't be where it is today.
It would not be where it is today, and we would be litigating, or would have litigated already, whether the police reasonably believed she was a lethal danger to them or to somebody else when they discharged their weapons at her.
Okay. And it's an interesting twist and sort of definition of the Fourth Amendment seizure. I'm wondering if you can talk a little bit more. You mentioned police don't necessarily have to formally arrest you for it to count as a seizure. What are some of the other ways the police can seize a person if it's not an arrest, and go into that a little bit more for us?
Sure. Sometimes people expect that the Fourth Amendment is a constitutional provision that regulates police investigations generally, and it's not. It is limited to specific circumstances that the Supreme Court has decided qualify as a search or a seizure under that particular provision. So a whole bunch of things the police do to investigate crime and people who may be involved in crime do not qualify as a search or seizure. And if the police engage in bad practices, it's not necessarily a constitutional violation. And some significant historical examples include cases, for instance, where the Supreme Court held that when we put our garbage out to the curb at night, the police can search the garbage bag or the garbage can without engaging in a seizure or a search for Fourth Amendment purposes. And intuitively, if we think of a police officer rummaging through our garbage bag at the corner, we think the police officer is searching the bag. And in literal or commonplace terms, that would be true. But it's not a search under the Fourth Amendment, because the Supreme Court held once we take the garbage to the street corner, it's no longer in our garage or in our house. We have surrendered any expectation of privacy in it that would be reasonable. And the Supreme Court has held that the Fourth Amendment is designed primarily to protect expectations of privacy in our person or in our stuff. Other examples include bank records. The police can seize bank records from your checking account, for instance, and the Fourth Amendment is not implicated because the court has held that once we give our stuff to a third party to hold, we surrender our expectation of privacy. Some limited phone records to the phone company also would qualify. In a seizure context, the court has held that when the police come onto a bus with the consent of the bus company and walk up and down the aisles with an armed and uniformed police presence, they're not seizing the people on the bus, even if the people subjectively might not feel particularly free to leave and not free to reject the questions. The court would ask whether an innocent, reasonable person would feel like the police had interrupted their movement or requiring answers to questions. And the court has said in that context, absent specific orders or commands from the police or the use of physical force, the people on the bus are not seized.
It's interesting. It's just another example of one of those places, particularly in constitutional law, where, as you said, the literal and commonplace definitions or the way we use terms aren't necessarily what the court cares about or is digging into.
They're always revisiting these questions, but for sure, there are aspects of criminal procedure and Fourth Amendment jurisprudence that don't always match many people's lived experiences. And that's the question of whether the court is too disconnected in interpreting the Fourth Amendment from the lived experiences of real people. The court is revisiting some of these issues, in particular with technology. In recent cases, the Supreme Court has held that we do have an expectation in certain technologies that we may give to technology companies if the police are using it to surveil us in a really global way, to follow our movements and track us for extended periods of time. But those dimensions of the Fourth Amendment are still uncertain. For this case, we have a very specific Supreme Court case that is the relevant entry point to the decision here. And it's a case called Hodari D. from California. And in that case, the police suspected a young individual of engaging in criminal conduct, but they did not have the requisite cause to arrest him or even to detain him temporarily for questioning. But when he saw the police, he ran, and the police chased him. And while he was running, he threw some contraband away for which he was prosecuted ultimately. And the question for the Supreme Court there was whether the police had seized him by chasing him under the Fourth Amendment, because if they found the drugs only while chasing him illegally, the drugs maybe would be excluded from the trial. But a majority of the Supreme Court held that if you are running from the police, you have not been seized by the police, you're trying to escape the police. And the court said, you need one of two facts to be able to establish the seizure. Either a police command or other show of authority, stop police, to which the person submits, hands up, I stop. At that point, you're seized. Or a police use of physical force to seize the person. So hands on the person, now you're arrested or seized. And at the point when the drugs came out in the Hodari D case, he was still running and had not submitted or been caught yet. Here we have the new question of what it means if the police use physical force, as identified by this Hodari D case, here deadly force. They shot Ms. Torres, but she still gets away. So she's still running like the defendant in the Hodari D case. Whether we have a seizure there. That's really the issue specifically for the court in this case. And you can imagine how that issue implicates so many other issues in public discussion and debate today about the police use of force.
For sure. And I want us to get into that a little bit. Before we jump into sort of placing this in a bigger perspective, if I can ask you to put on your prediction hat, what do you think oral argument in this case is going to be like? Do you think it's going to be, is this going to be a case where the justices are really active with each other, understanding it's going to be the telephonic oral argument, which is obviously a little bit different, and then maybe even gaming out a little bit further? Do you have any thoughts on how this may shake out and when we actually get an opinion from the justices?
Well, for reasons that may be apparent to our audience, I think we're in a particularly difficult time period to be in the prediction business with the Supreme Court.
Indeed.
And whether we even have 8 justices or 9 justices participating in the decision of this case. One particularly interesting wild card in this case is that this case implicates a 10th Circuit U.S. Court of Appeals decision. That's the court right below the Supreme Court. We have several of these Court of Appeals divided by circuit. But it dealt with this issue. Brooks is the name of the case. I can remember it because it's the same name I have. But what was particularly interesting about the case is it sided with the police in deciding that particular case, that if the police use deadly force but the person escapes, the person has not been seized until the person is caught or surrenders. And one of the judges in that 3-judge panel was then Judge, now Justice Gorsuch, who will be participating in this decision. And as a relatively recent appointee to the Supreme Court, along with Justice Kavanaugh, their jurisprudential perspectives on these issues are still uncertain. It's not clear that because he voted that way in the Brooks case that he'll necessarily vote that way at the Supreme Court level, because it's a different job at the Supreme Court. They're making constitutional law by interpreting the Fourth Amendment or other provisions. At the Court of Appeals, they're more trying to decide how the Supreme Court's rulings that bind them fit to a particular case. But it's interesting, nevertheless, as a wild card in gaming this out, that Justice Gorsuch was in that panel. And certainly I would anticipate the police officers may be looking to him in particular to tease out where he might be on this question. But it could be an active case because of these intersections with other areas of law, particularly because this case is a lawsuit and it's not a criminal prosecution where a defendant is seeking to exclude evidence. It implicates all these other issues that have been in the news about qualified immunity and indemnification in cases where the police are sued. If the Supreme Court rules that the use of deadly force is a seizure, regardless of whether the person gets away, police no longer will be able to claim qualified immunity in future cases, because the landscape of the law now will be confirmed by the Supreme Court. Same thing if the court rules in the opposite direction. We'll now have police who know that if the person escapes even temporarily, their use of deadly force effectively would be invisible to the Constitution for purposes of a lawsuit.
That has pretty profound consequences.
Could be very significant in both directions, and really speaks to this public debate about whether the law should impose more police accountability, particularly through lawsuits, as well as some other mechanisms in the use of force, especially deadly force, or whether the law should continue to protect the police. And the theory here is not protecting the police for the sake of protecting the police, but rather to avoid creating incentives for the police not to involve themselves in what can be uncertain and dangerous circumstances, because they're afraid that they'll be subject to liability if they make a debatable mistake. And that's the heartland of the debate. And you can see it in the arguments of the parties, this broader policy concern behind the scope of the Constitution here, of whether we want a clear-cut rule. If you use deadly force, the Fourth Amendment wants to know whether it's reasonable, regardless of whether somebody can escape afterwards, or whether we want to have these limits so that the police are not deterred from engaging in uncertain and dangerous circumstances. What's particularly interesting about the case is that it caught the attention of a lot of outside groups who filed companion briefs. They're called amicus curiae briefs, friend of the court. And the briefs came from a number of organizations, some that might be characterized as more progressive, and some that are not necessarily identified as more progressive groups. You had the Cato Institute, which is a well-known libertarian think tank, and the Department of Justice weighed in on the case. And all the amici in the case sided with Ms. Torres that the use of deadly force by the police should constitute a seizure. And the question for the courts instead should be what the scope of that seizure was if somebody escapes, because maybe it's the seizure starts, then it stops again, somebody escapes and is free again, and then gets seized again at a later point, and then whether that initial seizure was reasonable because the police reasonably believed that they or somebody else would be hurt or killed if they didn't use force themselves.
What I find so interesting about this case is the timing of it, that it was originally slated to be heard in the spring, and was one of the ones that was held over in light of the court temporarily shutting down due to the pandemic. And now we've had the entire discussion over the course of this summer on many of these policing issues and use of force. And now that it's been scheduled for this fall, I think a case that was maybe kind of just of interest to criminal procedure, Supreme Court nerds, has suddenly garnered a lot more public attention and is really could be a central part of these discussions that we've all been having in our communities, which is interesting to see happen with a Supreme Court case like this.
Absolutely. I think current events have sharpened the focus on and attention to these issues much more broadly. I'm part of the universe of criminal procedure and Supreme Court nerds who would have been interested in this case anyway. And of course, for those of us who have practiced in the area of criminal law or civil rights litigation, these issues are critical and have always been understood to intersect with these other concerns about race and police power and marginalized communities and what the accountability metrics should be for those interactions. But the events of this summer, particularly the Black Lives Matter protests and other events that have captured broad public attention to these issues, make this case one that may be on the radar of more people than it would have been.
Well, Professor Holland, thank you again for making the time both to write the preview article for us and for joining us today. It's been a great conversation.
My pleasure. Thank you so much for having me.